Hello, everybody. Mr. JJ is the most prominent corporate lawyer in the town. Guess what? I am JJ. Our focus today is the pre-incorporation contract. So I will just analyze on this. On the issue of pre-incorporation contract, the plaintiff contended that at the time of incorporation of the defendant, the first sales and purchase agreement was already executed. In analyzing this situation, the validity of the contract prior to the existence of the company shall be examined. The form of contract prior to the existence of the company was called pre-incorporation contract, which is our focus today. The relevant provision was embodied in Section 35 of Companies Act 1965. In Section 35, it states that any contract purporting to be entered by any person on behalf of a company prior to the formation of the company may be ratified by the company after the company was formed. After that, the company shall be bound and entitled to the benefits of the contract as the company had been in existence at the date of the contract. As for the case happened in between 1991, which was the date of the agreement was executed, until 1995, the date of judgment, the law to be applied was Company Act 1965. However, due to the amendment of the Companies Act 1965, the relevant provision governing the pre-incorporation contract has now become Section 65 of Companies Act 2016. Similar to Section 35 of the Companies Act 1965, ratification of the contract by the company will occur when the company is formed under Section 35, subsection 2 of Companies Act 2016. If the ratification does not occur, the person or the agent to the contract who act for the company is personally liable on the contract or the transaction. This principle is actually similar in between Section 65, subsection 1 of Companies Act 2016 and Section 35, subsection 2 of the Companies Act 1965. So let's break it down into a few elements. First, the section requires any contract or other transaction, which in our case, the contract was called the first sales and purchase agreement. Second, the contract was entered into by any person prior to the formation of the company, which in our case, the first SPA agreement was entered into on 12 April 1991. Third, the contract may be ratified by the formation of the company, which in our case we can see the incorporation of the defendant was on 25th of April 1991, and the contract was then ratified by way of resolution of the director on May 1991. Fourth, upon the ratification, the company shall be bound by the contract. As you can see in our case, the first sales and purchase agreement was then become valid by ratification of the company, and therefore both parties were bound by the contract. In this case, the provision was perfectly complied. Therefore, the pre-incorporation contract between plaintiff and defendant shall be valid. In fact, the similar principle had been decided in Privy Council in the year of 1981. The case was Cosmic Insurance Corporation Limited and Ko Chang Po. In this case, a letter was signed by the respondent before the formation of the company. The company was subsequently incorporated. The issue before the Privy Council was whether the letter signed by 12 persons, including the respondent, constitute a pre-incorporation contract. The Privy Council dismissed the appeal and held that the letter fell within the provision of Section 35 of the Companies Act 1965, and a pre-incorporation contract was subsequently ratified by the resolution of the director. Although this case was happened in 1981, but this case was cited again in recent cases. In 2019, a case named Koperasi Pembangunan Kampung was decided in the High Court of Penang, and another case was in 2016. The case was Alan Lee, Mason, and others, and Jeremy Kate Simstone, which the case was decided in the High Court of Kuala Lumpur. In the case of Koperasi Pembangunan Kampung, the first defendant approached the plaintiff and offered to complete a project. As a consequence, an agreement was entered between the plaintiff and the third defendant. However, the third defendant failed to commence the project pursuant to the agreement. Both parties mutually terminated the agreement, and the plaintiff lodged a private caveat on the property. The issue in this case was who are the proper parties to the agreement. The court saw this case in this way. The first and second defendant enter into the agreement as an agent for third defendant prior to its existence. Therefore, the ratification took place upon the formation of the third defendant. Therefore, the contract was binding on plaintiff and the third defendant. The third defendant was then ordered to pay the losses suffered by the plaintiff. In contrast, Alan Lee Mason and Jeremy Kensington, the court decided that the third defendant in this case was not bound by the alleged agreement. There was no evidence showing that the third defendant had ratified the agreement upon its incorporation. Yes, the section was well applied and I agree to this judgment.